Good morning, this is your Kelso Report for Wednesday, March 21st. I'm your host, Clark Kelso. We have 4 cases from the Supreme Court today to discuss habeas corpus, state sovereign immunity, patents, and workers' comp. And the Ninth Circuit had a banking law case, and we close with a case involving torts and probate. We begin with the Supreme Court of the United States, which gave us 4 cases yesterday, the first 2 by Justice Kennedy. Arizona does not permit a convicted person alleging ineffective assistance of trial counsel to raise that claim on direct review. Instead, the claim can first be raised only in a state habeas proceeding. In Martinez v. Ryan, the petitioner's state habeas counsel failed to raise an ineffective assistance claim, rather amazingly. After getting new counsel for the federal habeas proceedings, petitioner then tried to raise an ineffective assistance claim both as to the trial and the state habeas counsel, asserting a constitutional right to effective counsel in state collateral proceedings. Justice Kennedy, for a 7-2 majority, sidestepped that constitutional issue and held simply that in the circumstances presented, the federal courts must excuse the procedural failure to bring the ineffective assistance claim in state court. The Supreme Court remanded to give the petitioner an opportunity to raise its ineffective assistance claim before the federal district court. In dissent, Justice Scalia takes the majority to task for essentially achieving the same result as holding that there is a constitutional right to effective assistance of counsel by the expedient of holding that the federal courts, as an equitable matter, will excuse the procedural default. I think all Justice Scalia really proves here is exactly why Kennedy is reliably able to garner a majority of the votes on the court, while Scalia has marginalized himself by spending all of his time in dissent. He somehow hasn't figured out the value of compromise. Justice Kennedy also has our second case today. Now, Subdivision D of Section 2612A1 of the Federal Family and Medical Leave Act requires employers, including state employers, to grant unpaid leave for self-care for a serious medical condition so you can take care of yourself, provided other statutory requisites are met. The Supreme Court had previously held in 2003 in Nevada Department of Human Resources v. Hibbs that the Act constitutionally abrogated state immunity from damage suits with respect to a different subdivision dealing with so-called family leave for a serious medical condition suffered by family members. The holding in Hibbs was based on evidence before Congress that states discriminated on the basis of gender in granting and administering family leave policies. And so Congress had the power, given that evidence, under the 14th Amendment to abrogate state sovereign immunity. By contrast, there was no evidence that states had discriminated on the basis of gender or any other protected basis in granting and administering self-care leave policies. And absent that evidence, there was no basis for Congress to invoke its powers under Section 5 of the 14th Amendment. And in yesterday's decision in Coleman v. Court of Appeals of Maryland, Justice Kennedy wrote for a 4-justice plurality that the self-care provision of the Family and Medical Leave Act could not constitutionally impose damages upon a state for its violation. Justice Scalia concurred separately to make up the 5 votes for the judgment. He would have gone much further by essentially overruling Hibbs and holding that none of the Family and Medical Leave Act provisions can be applied against a state, because in his view, the Act goes far beyond anything that directly constitutes a violation of the 14th Amendment. Now we turn to the subject matter of patent and patent law, and what is patentable. The Supreme Court has repeatedly held that laws of nature, natural phenomena, and abstract ideas are not patentable subject matter. This limitation upon what is patentable under the patent laws ensures that the basic tools of scientific inquiry, natural phenomena and laws of nature, are not monopolized in a way that would stifle innovation and discovery. But since all patentable ideas are at some level built on the foundations of natural phenomena and laws of nature, drawing the line between non-patentable laws of nature and patentable inventions can be difficult. The court's jurisprudence distinguishes between a law of nature itself, which is not patentable, and, quote, an application of a law of nature or mathematical formula to a known structure or process, close quote, which may well be patentable. In Mayo Collaborative Services versus Prometheus Laboratories, the court had to decide on which side of the line a particular drug protocol fell. The drugs at issue were thiopurine drugs used in the treatment of autoimmune diseases. Now, a problem with these drugs is that the proper dose is influenced by each individual person's metabolic rate. Based on some prior art and additional research by the applicant, the patent set forth a precise protocol for how much thiopurine to administer based on the level of certain metabolites in a patient's blood. Well, the Supreme Court unanimously held that the patent was nothing more than a rule of nature and was therefore unpatentable. In particular, the court concluded that the analytic steps in the protocol, apart from the natural laws themselves, involved well-understood, routine, conventional activity previously engaged in by researchers in the field. In other words, apart from the natural laws, which the applicant certainly can be credited with discovering, there was nothing at all patentable in the protocol. Since you can't patent the natural laws, there is no patent coverage here. Next, we have a case arising under the Longshore and Harbor Workers' Compensation Act. That act caps benefits for most types of disability at twice the national average weekly wage for the fiscal year in which an injured employee is, quote, newly awarded compensation. Well, the plaintiff was injured in 2002 when her employer voluntarily paid disability for 3 years and then stopped. The plaintiff then filed a claim for benefits, and it wasn't until 2007 that the ALJ issued an order compelling further disability payments. The issue for the Supreme Court was whether the cap should be measured by the weekly wages as of 2002 or as of 2007. In Roberts v. Sealand Services, the court held by an 8-to-1 margin that, as a matter of statutory interpretation, an employee is newly awarded compensation when he or she first becomes disabled and becomes statutorily entitled to benefits, no matter whether or when a compensation order actually issues. Now, the statute itself was ambiguous on this question, but the court chose an interpretation that avoids gamesmanship in making claims and ensures equal treatment of similarly situated beneficiaries. And now we turn to the Ninth Circuit with a decision under FIREA. The plaintiffs in Benson versus J.P. Morgan Chase Bank were a group of investors who had been defrauded by the so-called Millennium Ponzi scheme. Their complaint alleged that Washington Mutual aided and abetted the Ponzi scheme by providing banking services to several companies controlled by the scheme's principals, despite actual knowledge of the fraud. Washington Mutual was taken into receivership by the FDIC pursuant to the Financial Institutions Reform, Recovery, and Enforcement Act, popularly known on the street as FIREA. And then its assets were sold by FDIC to J.P. Morgan, the defendant. FIREA requires that any claim regarding a failed bank that is seized by the FDIC must first be exhausted through the FDIC's claims process. Well, the plaintiff here argued that the exhaustion requirement applied only to claims made directly against the failed bank or against the FDIC, and that the requirement did not apply to claims made against a successor purchaser. The Ninth Circuit joined 3 other circuit courts in rejecting this argument as a too clever by half attempt to avoid the exhaustion requirement by strategic pleading, and the court affirmed the district court's dismissal of the complaint for failure to exhaust the FIREA claims process. Next, we turn to a torts case arising under California law. The county of Ventura owns and operates the Camarillo Airport. it had designed and maintained an extended area around the runway as a runway protection zone pursuant to recommendations in an advisory circular issued by the Federal Aviation Administration. Although the runway protection zone complied with FAA recommendations, the county had erected a fence across the protection zone to keep cars and people from entering onto the highway. The plaintiff owned a plane that had lost power shortly after takeoff and attempted to land back on what remained of the runway. Unfortunately, the plane could not stop quickly enough, and in order to avoid running into the fence, the pilot had to lift up on the brakes, coast over the fence, and then set the plane back down. In the course of executing this maneuver, the plane flipped over and was destroyed. The plaintiff alleged that the fence was an unreasonably dangerous condition on property maintained by the county. The trial court granted the county's motion in limine to prevent the plaintiff from introducing any safety standards that differed from the FAA's standards, effectively holding that the FAA standards preempted state tort law in this case. Well, on appeal in Sierra Pacific Holdings v. County of Ventura, the 2nd District reversed, holding that the FAA standards set forth in an advisory circular do not constitute federal law and do not preempt state tort law. The advisory circular standards were never embodied in a regulation, and the circular itself explained that the standards were merely advisory. In these circumstances, preemption simply does not apply. The court sent the case back to the trial court for further proceedings. Finally, a case involving probate. It appears that things got very confused procedurally in a state of Robert Clinton Moss, where the 4th District had to untangle the parties in the lower court to get things back on track. The spouse and executor of the decedent's estate had filed a petition to admit the decedent's will to probate. The decedent's son filed a pre-probate contest as permitted by law. So far, so good. At the hearing on the petition, though, the court got confused, and it granted the motion to admit the will to probate on the expressly stated assumption that the son could challenge the will subsequently. Well, when the son then tried serving the executor's attorney with a post-probate contest, the attorney first claimed that service on him was improper, since only the representative could be served. Well, the son dutifully complied, and the attorney subsequently then filed a demurrer against the post-probate contest on the ground it was barred as a successive probate contest, which you can't do under statute. Well, unfortunately for the Representatives' Council, the demurrer itself was untimely if you assume that the original service had been proper. By the end of the 4th District's opinion, we learned 2 things. First, service on a lawyer is good enough, and so the attentive demurrer was in fact untimely. And second, the statutory bar against successive probate contests applies only if the court has actually considered on the merits or otherwise a pre-probate contest. Where the court simply fails to consider at all a pre-probate contest, a claimant can file a post-probate contest. And this got sent back to probate court for more hearings. Hopefully the parties in the probate court will stop focusing on the procedural stuff and will get to the merits. And that's it for today's Kelso Report. Have a great day in the law.